Welcome to today's video, where we're diving into the fascinating and increasingly relevant world of cyber torts. This is simply about how the law deals with wrongful acts committed online. Think of it as traditional tort law like defamation, trespass, or invasion of privacy being applied to digital spaces. But the big question is, are cyber torts truly a new legal category or just old wine in a new bottle? Let's start with what cyber torts actually are. They are civil wrongs that happen in cyberspace, on the internet, through digital platforms, and they cause harm to individuals or organizations. These wrongs are actionable under tort law. For example, if someone spreads false information about you online that damages your reputation, that's cyber defamation. If someone persistently harasses you on social media, that's cyberbullying. If someone's personal data is stolen or exposed, that's a data breach or invasion of privacy. These are all examples of cyber torts. Now, critics argue that the term cyber torts is vague and unnecessary. They say the internet is just a new medium and the underlying wrongs like defamation or trespass are already well established in law. They argue that the core elements of tort law haven't changed. These elements are duty, breach, causation, and damages. I'll have to expand on the elements just briefly. First, duty refers to the obligation to take reasonable care not to harm others. This idea dates back to Buller's Nisi Prius, published in 1768, which stated that every man ought to take reasonable care that he does not injure his neighbor. Secondly, is breach, which happens when someone fails to meet that duty, either by doing something a reasonable person wouldn't do, or failing to do something a reasonable person would. A classic case here is the case of Donahue against Stevenson from 1932, which laid the foundation for modern negligence law. Thirdly, causation is about linking the defendant's actions to the harm suffered. It has two parts: factual causation, which asks whether the harm would have occurred but for the defendant's actions, and legal causation, which asks whether the defendant should be held legally responsible. Finally, damage, which refers to the actual harm suffered, whether it's financial, emotional, or reputational, and the remedy awarded by the courts. So, if these elements remain same, why do we need a separate category called cyber torts? That's where the other side of the debate comes in. Proponents argue that cyber torts deserve distinct recognition because the digital world introduces new challenges. For instance, online wrongs often cross sovereign borders, making it hard to determine which country's laws apply. Secondly, the scale and speed of harm can be massive. Think of a viral post that ruins someone's reputation in minutes. Thirdly, gathering evidence is also more complex, requiring digital forensics and specialized expertise. Now, how have legislators around the world started to respond? In the United States, the Computer Fraud and Abuse Act, the CFAA, prohibits unauthorized access to computers and allows civil suits under certain conditions. The California Consumer Privacy Act, CCPA, gives consumers the right to sue for data breaches with damages ranging from $100 to $750 per incident. In the European Union, the General Data Protection Regulation, GDPR, allows individuals to claim compensation for both material and non-material damage caused by data breaches. Nigeria's Cybercrime Act of 2015 criminalizes identity theft, cyber stalking, and data breaches, and even provides for restitution to victims, laying the groundwork for civil liability. A few cases that illustrate these points are the recently decided case of Buren against United States 2021, where a police officer accessed a law enforcement database for personal gain. The Supreme Court clarified that under the Computer Fraud and Abuse Act, someone exceeds authorized access only when they access parts of a system they are not allowed to. In other words, if you have the keys to a house, you're allowed access to every part of that building the key can access. You only exceed your authority in situations where, for instance, using the building analogy, you get to a locked door, you don't have access to maybe the master bedroom, and you force your way in. This case is crucial for cyber torts because it sets boundaries, technical boundaries for what counts as unauthorized access in civil suits and what a plaintiff ought to prove to establish breach. Another relevant case to our discourse is CompuServe Incorporated against Patterson 1996, which dealt with jurisdiction. Patterson, a Texas resident, used CompuServe, an Ohio-based internet service provider, to distribute software. Patterson also entered a shareware registration agreement with CompuServe, which included an Ohio choice of law clause. When a dispute arose, the court held that Ohio had jurisdiction because Patterson had purposefully engaged in commercial activity with an Ohio company. This case shows several things: that online interactions can create legal ties across borders, which is a key issue in cyber torts. Also, that digital conduct can trigger legal consequences in the forum where the platform is based. Also, that online contracts and transactions are actionable under tort law. And finally, that forum selection and choice of law provisions are enforceable even in cyberspace. What's the key takeaway? While cyber torts share the same legal DNA as traditional torts, the digital context introduces complexities that justify treating them as a distinct category. The challenges of jurisdiction, the scale and speed of harm, the nature of evidence, and the evolving legislative landscape all point to the need for tailored legal responses. Cyber thoughts aren't just a conceptual misuse, they are a necessary legal innovation. Thanks for watching. If you found this breakdown helpful, don't forget to like, subscribe, and share. Let's keep the conversation going about how law is evolving in the digital age. Until next time, please be safe. Thank you.